Hi, my name is Pedro Moniz Lopes. I'm a professor at the University of Lisbon, and I'm here to talk to you about what can one expect and get from logic in the law. So this is a 10-minute class. I'll be very brief on such a heavy topic. And I'll just start out by saying that everything that will be said here can and should be developed in further classes of the specific topics. So my purpose, to the extent that I wish to be understandable, is not to go deep into the formal logic, but to briefly outline the advantages that one can get from knowing a little bit of logic when applying it to legal reasoning. So, I will start by saying that traditionally, there is some sort of relation of attraction and repulsion between logic and law. So it is not uncommon for legal theorists to become enamored or how can I say it, excited over logical reasoning and even become logicians themselves. But at the same time, so that's the attraction. But at the same time, it is not uncommon to have lawyers that describe others as formalists or pedantic if they apply logical tools. So the repulsion here is very well described in a well-known passage of Oliver Wendell Holmes, the well-known legal scholar and justice for the Supreme Court. In his book, The Common Law, he said something like, the life of the law was not merely logic, but experience, and it could not law could not be dealt as if it contained all the axioms and corollaries of a book of mathematics. So there you can see the repulsion between law and logic in the sense of a certain fear of logical theology or theocracy or logicocracy, however you want to call it, um, as some sort of cold, hyper constraining, not adaptive, not customized, unfair way of dealing with law. There are some. There's a lot of papers, of course, about this, and I wanted to indicate two. There's a well-known paper by Susan Hack on logic in the law, something but not all. It was published in Ratio Juris in 2007, and there was a reply by the Argentinian legal philosopher Eugenio Bulligin. What can one expect from logic in the law? Not everything, but more than something. So there you can see some sort of debate on whether logical tools as applied to legal reasoning would be advantageous or not. So, as I was saying, this tale of attraction and repulsion is revolves around the fact that logic is abstract. It has to do with the extraction of formal data. It is closed. At least I'm generalizing. There's many systems of logic, but usually it is closed. It is fixed and complete. It is constrained. It constrains. It is rationally impossible to be refused. It is formal, it is objective, it is rigid, impersonal, and whatnot. Whereas legal reasoning um, tends to be seen as specific, particular, concrete, having to do with a certain case, open, admitting many balancing alternatives, persuasive, connected to rhetoric, according to some visions, material, personal, evaluative, and flexible. So you can find a lot of people sympathizing much more with this open way of reasoning, to which logic tends to be seen as some sort of an enemy. So, but there's some misunderstandings regarding what logic is and what logic is not. So for the purpose of what I'm talking about, logic is not equivalent to rationality. It's not equivalent to reasonability. It is certainly not equivalent to rhetoric, and it is, so it is said, it is not psychological. So logic is what Quine, a famous philosopher and logician, called the science of necessary inference. It is the study of what constitutes good and valid reasoning. As applied to law, when we apply logic to law, and I'm borrowing a Dutch legal logician, Alan Zotman's account, logic as applied to law has to do with how far the conclusion of a legal argument is sufficiently supported by its legal premises, in an anti-psychologist manner. So it has nothing to do with whether somebody feels compelled or has a mental state, or an attitude regarding something. It is anti-psychological in the sense that it has to do with the structure of thought and not with the logic has to do with the structure of thought and not with the process of reasoning. So, or the process of thinking. So within logic, you can have many systems, of course, but there's a main division that tends to be structured between formal logic and non-formal logic. So formal logic has to do with on what conditions can a given statement be considered as a conclusion drawn from certain other statements. Non-formal logic has to do with how conclusions are drawn in different fields of science. It is tends to be more tolerating and, of course, not reduced to logical formula. Before proceeding, it's very important also to clarify the distinction between valid arguments and sound arguments. So in logic, we deal with valid arguments, and by valid arguments, I mean the fact that for an argument to be formally valid, the truth or falsity of its premises is irrelevant. So you do not need to know exactly what you're talking about to logically reason. The premises need not be true. You can have formally valid arguments drawn from false premises. So, and they can be valid arguments. Sound arguments, on the other hand, are much more important for lawyers, of course, because sound arguments are not only valid in a formal sense, but they also have to have truth premises. And this is very important because while valid arguments in formal logic tend to have to do with internal justification, and internal justification in turn has to do with the derivation of a certain decision from general legal rules. That is, the truth of valid conclusions is inferred from the truth of valid premises. Sound arguments have to do with the conjunction of internal justifications, as I described just some seconds ago, with the conjunction with internal justification with external justification. That is, the derivation of these premises from further external assumptions, and And the external justification has little to do with logic. Well, it can have some relation with logic, of course, but it has to do with the appropriate selection of premises under a certain criterion of soundness, and that criterion may or may not be logical. So when we're talking about law and logic, we should first and foremost moderate our expectations in order not to be disappointed. So in law, for instance, logic will not help you identify sources, interpret texts, qualify cases, or balance in the largest sense of the word. It may or may not help you in adopt and select certain interpretive theories or striking analogies and distinguish cases from others or classes of cases from others, maybe filling legal gaps in legal systems and distinguishing between rules and principles. It will most certainly help you with clarifying legal sentences, using and defeating legal arguments, identifying legal positions, justifying legal decisions, and identifying legal gaps or complete legal systems, as well as using precedents and identifying consequences of norm derogations to certain legal systems. So you see that logic in law tends to be, on the one hand, much less valuable than those who have this idea that logic can solve many legal problems, which is hardly the case. So logic has nothing to do with the specific meaning that a certain text has, or the attribution or the ascription of a certain meaning to a certain text, but it has to do with spotting conflicts between applicable norms, helping out in solving those conflicts and deciding which is the applicable norm to a certain case. Those are logical steps in which using logic helps a lot. Now, I want to finish off by saying that when we talk about logic, we're not talking only about deduction. So it's well known that there are many logical moves. The most well known is deduction, and as applied to legal reasoning, has to do with modus ponens, something that I do not have the time to go into now. But basically, deduction is sort of non-expanding logical move in which we get this rule, all A's which are B are C as a premise. We have the case A is B as a premise as well, and we get the conclusion A is C. So you have all men are mortal, Socrates is a man, Socrates is mortal. That's the basis of deduction. But then we have induction as well, which is some sort of changing the order of the premises and the conclusion in the way I said it before. So you have a premise which is case A is B, and you have a result that A is also C, and then you induct a rule. So you spot a tiger that is white, you spot another tiger that is white, and the third tiger is white as well, and you induct a rule according to which all tigers are white. So all X's which are tigers are also white. And this is very important to in legal reasoning justify the creation of legal principles. So legal principles tend to have this sort of or they do have this sort of generalization / induction basis over specific rules. So if you have certain rules of specific kinds that have similar consequences, then you can induct general principle out of it. I will finish off by saying that there's also another logical move that is very important, although some people debate whether it's logical or not, which is the abduction. Abduction, of course, has nothing to do with being abducted by aliens. It's a logical move that was championed by Charles Peirce, a famous American philosopher. And getting back again to the order of the premise conclusion that I mentioned before with deduction and induction, the abduction. Abduction, of course, has nothing to do with being abducted by aliens. It's a logical move that was championed by Charles Peirce, a famous American philosopher. And getting back again to the order of the premise conclusion that I mentioned before with deduction and induction, in abduction, what you have is a certain result, A is C, as a premise. Then you have come up with the best possible explanation for that being the case, that A is C, and by that you ground yourself in another premise, which is a rule or a causal process, according to which all A's which are B are also C, and you arrive to the conclusion that A is B. And this is very important because it has to do basically with evidentiary reasoning. In legal reasoning, we, of course, many times, both as scholars or lawyers, tend to discuss the best possible explanation or the inference to the best explanation of a certain event. And with that, you have certain different contrasting hypotheses that help explain that event, and in doing so, you abduct the cause for that event, whether it's a murder or some sort of legal outcome that was the case, that whether it was being trialed or discussed legally. So these were just some examples of how we can have a more rigorous and correct reasoning with using logical tools. As I mentioned before, now we can divide each of these specific topics into many other topics, molecular topics, and those would need a specific class of their own. So I hope you enjoyed it. Thank you very much.